Talking cricket now on the SportsMax Zone. The Trinidad and Tobago Cricket Board has a new constitution. That new document was passed at a meeting on Saturday, October 2nd. The biggest change is that presidents will now serve a term lasting 4 years, up from the previous 3. Term limits have also been implemented, meaning that presidents cannot serve for more than 2 consecutive terms. However, a person who has served as president can return down the road again to serve that office. Under the new constitution, nominations for post at election time will be limited to 1 position per person. All nominations for office must be made 2 weeks before the election. An invitation was extended to the Trinidadian cricket fraternity to submit comments on the new constitution, but only Zaheer Ali took up the offer. Ali, a former left-handed middle-order batsman, played for the Windies at the Under-19 World Cup in Sri Lanka in 2000. He also captained the Under-19 and Under-15 Windies teams. In a letter to the TTCB, he wrote, "The provision that the president shall not serve for more than 2 consecutive terms should also include that the president shall not be eligible to serve in any position in the TTCB executive unless a term has passed. Additionally, it should be extended to the 6 elected officers to avoid a revolving TTCB executive and to promote transparency and enhance the governance capability of the board." Ali, who is an attorney at law, joins us now. Welcome.
Good evening, and thanks for having me. Good evening to the rest of the Caribbean and all your viewers and listeners.
Thank you, and no problem. So I start by asking you about these changes that have been made to the TTCB constitution and your take on that.
Well, let me acknowledge that I'm always an advocate for constitutional and legislative reform. But having reviewed the most recent proposed constitutional reform, I am concerned and worried that the opportunity to promote the objects of the Trinidad and Tobago Cricket Board and to promote transparency, accountability, and good governance has not been represented or reflected in the proposed constitutional amendments. And this is of concern to me. What is even more concern is having written to the Trinidad and Tobago Cricket Board after learning about a constitutional reform that's in flight, I submitted my proposed recommendations for consideration. And I subsequently learned through the open forum that it was not entertained, it was not considered in any meaningful way. And again, that creates concern for me. Why I'm saying it is of concern to me and hopefully concern to the rest of the stakeholders in Trinidad and Tobago cricket is because the Act of Parliament has afforded the authority to the Cricket Board to make rules for the proper governance of cricket. And that will be built on the premise that there is wide consultation with all individuals who will be expected to make a contribution or who the rules may impact. So in that context that I'm very concerned, and I'm actually asking Trinidad and Tobago stakeholders to unite to really challenge this issue lawfully so that there'll be good governance and the whole perspective of constitutional reform will be justified and represented.
Yeah, you speak about no accountability and transparency. Can you point to us just some certain points that were made on Saturday that you feel as if, you're not okay with?
Well, I wasn't privy to the meeting on Saturday because I wasn't given a chance to be heard at the meeting despite my application. But what I can tell you is that from the proposed constitutional amendments that I applied and obtained, when I reviewed it, I recognized that the issues of accountability in the context where Trinidad and Tobago Cricket Board are the recipient of substantial government and state funding. And one would have expected to see that the rules are amended to attract public audits so that you will promote transparency and accountability. So that's number one. Number two, the present configuration of the Trinidad and Tobago Cricket Board give rise to serious conflicts of interest, where the affiliates of the Trinidad and Tobago Cricket Board, and I give an example, maybe a president of or a secretary of an affiliate, is now voted into the executive of the national authority. So the question that begs is, where does the best interest lies? Does it lie in the best interest of Trinidad and Tobago cricket or in that particular affiliate? And thirdly, just to highlight some of the major points, what is really shocking is that with a public authority exercising a public function, the access to the court or an independent tribunal for disputes have been taken out. So I am actually concerned, where is the proper administration of justice? Where is proper governance and democracy in relation to the governance of the Trinidad and Tobago Cricket Board? May I also say that in looking at constitutional reform, one would have anticipated an avenue for coaches to be heard at the national level, especially where all administration are geared towards cricket, and coaches play an instrumental part in cricket. And if by extension we are looking at the development of West Indies cricket, it has to start at the regional board. So those are some of the issues that I'm highlighting. There are other issues, but in the interest of time, unless time permits me, I can identify a few other areas that I've found that should have been considered in the reform.
Just to be clear on what you said, Counsel, are you saying that the grievance procedure, I'm calling it that, in the Constitution, was it modified from what it was, or are you saying based on how it existed before this latest go-round of amendments that it was found, in your estimation and your opinion, to be lacking?
Well, what the Constitution was prior, it did in fact give an access to the High Court, and the record will show that several matters were taken to the High Court by different litigants. What we found now in the proposed amendments, which was adopted on Saturday from all indication, is that they have now removed that access to the court, and they have built-in mechanisms. Now, while I acknowledge built-in mechanisms in relation to looking at alternate dispute resolution, because it's a public functioning body, attracting substantial state funding, you do not want to take away that last resort access to a court for justice, or if there's an an independent tribunal of the TTCB, those will promote proper administration of justice. As it stands now, they have basically taken away that access to the court, and I think that's going to meet a legal challenge.
I'm shocked at this, Counsel, because I can't imagine that the recourse to the courts is a no-no. I can understand an organization trying to set up its ship in such a way that before matters, that is not a willy-nilly decision to just go to the court at the first instance of a grievance, that you put internal facilitations in place to air grievances and come to an amicable solution before it gets to the level where where litigation is sought and you have to proceed to a court of law. But I'm shocked by what you say, that the recourse to the courts, based on your understanding, that has been removed completely?
Yes, from my reading, from what was presented to me and what I responded to in my recommendations, I identified that was an area that created a real concern. So, as I said before, that I am all for alternate dispute resolution. But having said that, as you rightly said, you cannot take away the access to court with a public body, a national authority that is exercising a public function. And if you look around the world, may I just say that there is sufficient persuasive authority, for example, the BCCI case.
I'm still gobsmacked by that. We need to get to the heart of this matter. That point deserves. If we weren't going to follow this story, we would have. We need to follow it with more passion, fervid following up of that because of that factor. I can't believe that. Beyond that,
what I can say to you, George, is that I've written since learning that they have not entertained meaningfully the recommendations based in the public domain. I've written to the TTCB. Asking for information in relation to the level of consultation and whether, in fact, they have considered my document at all. So I'm actually awaiting as we speak for a response from the TTCB, which has yet to be obtained.
All right. So I was going to come to that because I heard you in your opening response to Mariah say that your recommendations were not considered in a meaningful way. And immediately my antenna went up because I'm saying, well, my first impression was that your recommendations were not considered at all. Can you clarify whether it's that they weren't considered at all or whether they weren't considered meaningfully, and what, from your view, would be a meaningful consideration of what you submitted?
Right. So on writing the cricket board to be heard in the actual meeting, I was denied the opportunity to be heard at the actual meeting to make full representation in relation to my recommendations. However, I was afforded two opportunities, one with a Zoom meeting to speak with one or two of the members of the board, and also to forward my recommendations to the General Secretary of the board, who gave an undertaking to circulate it to all members. So hence I'm saying that meaningful in the context where, while the opportunity was there to submit the recommendations, it didn't go further than the submission, based on what I've learned from an executive member who spoke openly in recent times.
Right. So the crucial part of that promise that you were giving, that undertaking, that they had the undertaking that they would they would circulate your submission for the consideration of members. You're saying that based on your information, that was not done.
Well, based on the record, based on the open source, I have learned from an executive member who spoke publicly that it was not entertained in the meeting or formed part of the minutes of the meeting.
Right. And of course, Counsel, you know very well that if it is that they are inviting submissions, they aren't compelled to consider the submission in the way that a reasonable person would find it to be acceptable or satisfactory. Because in those cases, people might have different views on what they deem to be meaningful. But where constitutional reform is concerned, one would have thought that they would have at least discussed and then said to you, well, Zaheer, we are not accepting these recommendations at this time. And you're saying that because they didn't even give you that courtesy and didn't even allow the members to inform themselves about what it is that you were recommending, that for you fails to pass the test of a meaningful consideration of your submission.
And I will agree with that because just to expand it a little bit, and I just go back to the Act of Parliament that granted the authority to make rules. Very wide discretion, and one would anticipate that as a public functioning body, that while I heard about it and make recommendations, I'm hearing that the degree or the level of consultation is uncertain. There's no record as to what level of consultation was had. So hence I have now forwarded this letter on Tuesday to get clarity as to what is the degree of consultation and what degree of consideration, if at all, was given to my proposals.
Yeah. Finally, Zaheer, we're running out of time, and we promise you that we will follow through on this, because we're hearing some things here that really they can't be allowed to abide if indeed it is as you say. Your fundamental gross with how the TTCB, the framework for its operation is right now, is that perhaps it is that persons who serve terms of office, say for instance in the office of president, and you serve those 2 consecutive terms, that you're saying that there should be a natural separation of that person from the decision-making body of the TTCB to allow fresh ideas to come in. And if that person so desires and has the requisite support, they can come back at a later cycle to again contest for the post of president, rather than to be a looming figure hovering over the new president because they can sit on the board under the current rules. And you're saying that that arrangement is unhealthy for Trinidad and Tobago's cricket. Is that what you're saying?
Yes, of course. I think that what I propose is that an extension of what already existing, where they agree to have term limits. After 2 terms, the president will not be able to serve in the office of president. I am saying that there should be a lapse in 1 tenure or 1 term, and then the president could make application for any office again. But if you don't allow that, what you have the opportunity, the potential for a revolving executive. So, for example, you're president for 2 terms, and then you strike or allegedly strike an agreement with other persons in the executive to say, okay, I'll go to first vice president and you'll go to president. When the president is not there, automatically you'll be acting president. So generally, this revolving executive, it creates the potential for that. So hence, we need that break in order to have that rotation for the proper administration of cricket and to ensure there's transparency and accountability and good governance.
Yeah, and where you don't have that rotation, you have what Professor Alvin Wynne said once at a CARICOM function, Zaheer Ali, was a homogeneity of ideas and almost a certain group ring-fencing the leadership position and not allowing other talents to shine through. We're going to follow through on this. We thank you very much for speaking with us, and you'll hear from us in the future.
My pleasure. Thanks for having me.
Excellent.